And just to remind folks of our agenda, now we're moving in for the last sort of main topic of today's discussion is heirs property. And then just to also remind folks, this is part of a 2-day workshop. And tomorrow we have another action-packed day all around planning and process for technical assistance in the areas of identifying partnerships, markets, farm stress, mental health, and a discussion on equity and justice. That's just a little snapshot of tomorrow as well. We hope you can join. But with no further ado, I'd like to pass it over to my colleagues, Sam, Robert, and Elena on now our topic discussion on heirs property.
So today's topic is land utilization and heirs property. Michael was not able to join us, but I'm back with you. I introduced myself earlier. Next slide. Our two dynamic speakers joining me is Robert Zimbabwe from Tuskegee and Lourdes Elena South from NRCS on the implementation and stewardship branch for easement and programs. And she works with the historically underserved working groups. Next slide. So today's overview is a definition and actions around what is heir property, what's the impact of heirs property, and what can be done to address the ownerships of heir property. Next slide. So what is heirs property? It is land that is held without a secure title. It is also called family land, estate land, deceased et al., also spelled as H-E-I-R-S, sometimes H-E-I-R''S, and most of the time is H-E-I-R-S with an apostrophe. All of these things are typically located if you're trying to do a title search, but most importantly, there's lots of other ways that you may see it in writing, but most important way is looking at it as multiple landowners joined together who has the title still titled in someone else's name, and it's most likely a deceased person. Next slide. It is a subcategory of tenancies in common ownership that occurs when individual tenants in common do not own any part of their shared parcel, but instead own a fractional interest in the undivided whole. So let's assume we have 10 landowners that have what they call a fractional ownership of it, and it's 10 acres. Not all 10 will likely own all an acre apiece. They will have a fractional ownership. So the number of heirs associated with it have to be titled back to the deceased person's name to determine how many heirs have legal ownership down to what percentage of that ownership to the whole. But they all share the same interest of ownership as in what they can do with the land. And paying the taxes, which you'll hear later on, does not provide them with ownership status. Next slide. What is unsecured title? Owners of heir property do not own a specific portion or acreage, which is what we just described. Rather, they own a percent of interest in the land, which is based on their relationship to the original landowner. Owners are called co-tenants in common. So here's an example. A farmer owns X acres of land, and they have 4 children. If the farmer dies without a will, also called intestate, then each of the 4 children receive 1/4 or 25% of the land. All 4 of those children have equal rights to that X percentage of land. So not one can have more ownership than the other. They each share the same percentage within the total. Next slide. So now Dr. Zimbabwe will take you through who has heir property and how it entails ownership.
Good morning, everyone. I'm Robert Zimbabwe from Tuskegee University. It's a pleasure to be with you all on this topic of heir or heirs property. And a good question is, who has heirs property? And really, it's anyone. You can be a young person, an older person, you can be a producer, you could be an academic, or they could be both. You can have multi-generational owners, or it could be first-time owners who don't have a will. Basically, it's determined by birth and death. So you can have a person who has 1 child or 2 children, or someone who has no children, or you could have someone who dies early and then their children are on the same level as their parents, brothers, or sisters. So it's anybody could be an heir property owner. Next slide, please. So why is there heir property? And it's because there's a lack of a will or estate plan. And some people say, well, why don't people have wills? And you could ask yourself that, because I can imagine that 50% of the people that are on this call probably don't have a will. And reasons why people don't have wills are, one, they don't perceive that they have no heirs, no children, so why do I need a will? And then we can come back and say, you can will your estate to anyone or anything. And two major examples might be your church, your college, your high school, your fraternal organization, so on. Excuse my cat. People don't have wills because they want to avoid family conflicts. That is, instead of saying that a son gets this part, a daughter gets this part, or whatever, they say, I'm going to let them decide after I die. But actually, that just moves the problems to the next generation. And then another reason is a cultural preference or family desire. That is, some people say they want to keep the land as their property so that everyone has a piece of the pie. It is that they have a place that they can always come back to that's family land. The problem with that is that only works as long as it works. And we'll talk about that in just a few minutes, dealing with partition sales. Another reason is that it's a feeling that to talk about death brings on death. So people wait and wait and wait because they don't want to talk about it. And then all of a sudden, guess what happens? It happens. Next slide, please. So how do you avoid heir property? Well, you do it by writing and having an estate plan or a will. You can create a limited liability corporation or a trust. But basically, at the end of the day, you're going to need a lawyer. And so, and the thing is, the sooner you do it, the better you can do it. I mean, the easier it is. So one thing that we talked about with this presentation is that we are not lawyers. So this is not, technically, this is not legal advice, though Elena South is a lawyer. But we are not giving that legal information, but information that you can take to a lawyer to ask further questions. Next slide, please. Okay, what is the impact of having heir property? Heir property restricts how land can be managed because typically all the heirs need to agree on any decision concerning the land, including the division of profits. So for example, if you're harvesting timber or reforestation, mineral rights, mortgages and other loans, some USDA programs, and conservation easements. In the example of timber harvesting, for example, a certified timber harvester has to get the approval of all the heirs before they can harvest the timber. If they don't, technically, they are breaking the law. They know this, so they're going to charge a premium for doing this, which means that the landowner is going to get less. At the same time, the landowner, the technical person who's engaging this person, needs to divide or should divide the profits among all the other heirs based on their percentage interest. Whether that happens, who knows? Also with mortgages and loans, banks tend not to give mortgages on heir property unless all the other heirs sign on, and banks are still reluctant to do that. So again, you're limited in what you can do with the land. Similarly, with permanent improvements to land on USDA programs, they don't want to do this unless all the owners agree. Because all it takes is one co-tenant to say, I didn't agree to this, and then things fall apart. Next slide, please. Two other impacts on heir property deal with tax sales and partition sales. So there's usually one person in the family that is in charge of paying the taxes on the land, usually a person who lives in the same county and may even live on the land itself. That is, they are in charge, they pay the taxes. Now, one question I always get with workshops is, I pay the taxes, therefore I have more rights to the land. Unfortunately, that is not the case. That is, what you should be doing is everyone, or have everyone pay a share of the taxes based on their percent interest in the land. The fact that you pay all the taxes just shows that you are a good person and they're benefiting from your generosity. Now, in Macon County, Alabama, for example, taxes on land are due in October. They are not delinquent until December 31st. Then, April of the next year, they have, or the Revenue Commissioner's Office has what they call an auction of tax deeds. That is, they auction the debt of the taxes on a piece of land. And then people can purchase these slips of paper onto the land. If they pay those taxes 3 years in a row, they get the security of that land. Now, the owners of the heirs property can, up to that 3-year period, buy back that tax deed. That is, they will pay the person who's been paying the taxes what they've been paying plus a 12% interest. So what you'll have in these tax sales are people who are buying land or buying these tax deeds, not necessarily interested in the land per se, but are interested in the interest if the owners come back and want to reclaim their land from the tax sale. Now, some people say, well, what if somebody starts paying my taxes for me? The tax sales only occur if the taxes are delinquent. If they pay, someone pays your taxes before the delinquency, which is December 31st, congratulations, no one has paid your taxes for you. It's only after they become delinquent that this becomes in effect. The second occurs with partition sales. Partition sales occur when somebody who has an interest in the land decides that they want their share. That is, they want actual acres. Okay, that is, if you have 100 acres and someone has a 50% share, they say 50% of that 100 acres is 50 acres. I want that 50 acres deeded off and in my name. Now, in most cases, land is not even. So in that 100 acres, you might have a pond, you might have some wasteland, you might have some forest, you might have a house. So how do you determine who gets how much land based on their percent interest? Now, a partition in kind occurs when the co-tenants agree that this is the land that will be given to the person who wants to have their piece of property. That is, there is agreement, and that person takes their interest, and then they can get a deed that's in their name. However, if the parties involved, all the co-tenants, cannot agree to this, then a partition sale may be have to occur from the courts. And in that case, all of the land is auctioned at the courthouse, and then the whole sale is then divided up among all the co-tenants based on their percent interest. Now, the tricky thing with partition sales is when you have percent interest as a co-tenant, you can sell your interest to anybody. It could be another member of the family, or it can be an outsider. And what has happened in the past is that people will look at the record and find some heir property, and they can find out, oh, wait, there's somebody that has a 0.1% interest that lives out in California. And they'll contact that person and say, you know, I'll give you $1,000 for your small percent interest in land that you may not even know you have an interest in. And that person says, wow, $1,000, sure. And they draw up the legal documents, and that person transfers their interest to this outsider. Then that outsider is now has an interest as a co-tenant, just like any of the other family members, and then they can force a partition sale. That's how a lot of Black land has been lost through time. So partition sales, tax sales, something to look out for. Next slide, please. Some of the results from owning air property, at the individual level, you have loss of investment value and you have loss of potential revenue. That is, because you have air property, you can't improve the land as readily as if you had clear title. That is, you can't put a barn on it because, well, I can't get money from the bank in the form of a loan. I can't put up fencing. I can't get that pond put in. All these things that if you had clear title would be available to you. Because of that, the land will always have a certain value, but won't increase it in value. Second, that means you have a potential loss in revenue. Because you can't improve the land, you can't then improve your production or its real estate value. For the community, that means if your land doesn't improve, they don't get to increase their taxes. That is, air property on the whole is going to be assessed at a lower value than land with secure title because its investment value isn't increasing, its potential value isn't increasing. So that's a loss of taxes to the community, which then affects schools, your roads, your hospitals, fire department, and things like that. Then also air property, in many cases, you have absentee ownership, then you see depreciation because it's not kept up. And the houses are run down, fences are let go, and so on. So air property can lead to this decline for both the individual and the community. Next slide, please. Okay, my colleague, Elena South, will now take us through two important pieces of legislation dealing with heirs property. Elena.
Hello, my name is Elena South, and I'll be talking about the Uniform Partition of Heirs Property Act, or the UPHPA. And forgive me if I forget one of the P's when I use the acronym. So next slide, please. So first, important note, if you do not decide how you want to divide your estate now, the state in which your death is probated will, i.e. it will pass through intestacy statutes, and like Robert said, you might not think you have heirs, but depending on the way the state statute is written, it's usually everyone you share a common grandmother with. So your siblings could be considered heirs, your parents could be considered heirs, your aunts and uncles, all the way up to your grandparents could be considered heirs, and that can lead to a very fractionated interest among your whole family. Next slide, please. So, the 2010 Uniform Partition of Heirs Property Act was drafted by the American Bar Association by some premier property law attorneys, and it provides a series of due process protections in state court when a partition action occurs. And I'll define that a little bit more. Robert has already defined it. But so essentially these due process protections are notice, appraisal, right of first refusal, and if heirs do not exercise this right, a sale is required, a commercially reasonable sale supervised by the court to ensure that a fair share is given to all the tenants. And I'll unpack what that means. So first, why the UPHPA was needed. So as we've been stating, heirs property occurs when real property is passed through intestacy, i.e. a landowner dies without a will. And real property is just a legal term to say land or house, right? So real property is passed as heirs and tenants in common under state law. So think of this as having an interest in a corporation, a shares in a corporation. You don't own a specific part of a corporation, you own an interest in the whole. And that's exactly how heirs property works. So this means that one heir can force a partition sale, which is a type of partition action. So tenants in commons means that they each have this undivided interest in the whole, but they also have exclusionary right. So one heir can bar an action from occurring on the land, and one heir can start an action, such as a legal proceeding for a forced sale. So it's the majority of heirs are beholden to the whims of one. And what real estate developers have taken advantage is they often buy a small share into heirs property by buying out a tenant in common, and then they file partition action. So essentially, where was I? Oh, yes. So I was talking about partition in kind, which is the least preferred method by the court, because you would have to go and essentially divide up the land among a multitude of co-tenants. So the partition action for sale mechanism being used by real estate developers to acquire an interest and then force a sale through this debtor-creditor mechanism liquidates the asset as soon as possible. So the real estate, and this depletes the inherited wealth that asset represents, and it doesn't take into account cultural ties to the land as well as other factors, like there may be an heir living in this home and might be rendered homeless by the sale of the land, right? So so the UPHA applies to heirs property, which means and is defined, oh no so which means that one or more co-tenants must have received his or her property interest from a relative, and there must be no written agreement governing partition among the co-tenants or co-owners. Those are the two prongs for when the UPHPA is triggered, right? Because if you have this agreement, then there is no undivided whole. It has been divided, it has been settled. So essentially what needs to occur for the UPHA to be, for the substantive due process to be triggered is a forced sale of some sort, an action, a legal proceeding. And as I stated, you would get the co-tenant requesting this partition sale must give notice to all co-tenants. The court must order an independent appraisal to determine the property's fair value market value of that parcel or house or real property, which is not what you see in states that don't have the UPHPA. If any co-tenant objects to the appraisal value, the court can hold a hearing, which would consider other evidence. Any co-tenant except the co-tenant requesting this partition by sale may buy an interest of the co-tenant seeking partition for a proportional share of the court-determined fair market value. This is the trigger of the right of first refusal. And any co-tenants have 45 days to exercise this right of first refusal, and if exercised, another 60 days in which to arrange financing. So if more than one co-tenant elects to buy the shares of the co-tenant seeking partition, the court will prorate the seller's shares among the buyers according to their existing fractional ownership percentages. If no co-tenant elects to purchase the shares from the co-tenant seeking the partition, the court must order a partition in kind, which then divides it among all co-tenants. You know, if a partition in kind isn't appropriate, the court orders a partition by sale that is open to the market and no price lower than the court determined value of that appraisal for a reasonable period of time. So the co-tenants have an ability to actually get what that land is worth. And that is essentially how the UPHPA protects heirs when these partition actions occur. Now, the states that have passed the Uniform Partition of Heirs Property Act, as you see here, are Nevada, Georgia, Montana, Alabama, Connecticut, Arkansas, Hawaii, South Carolina, Texas, New Mexico, Iowa, Missouri, Illinois, and the Virgin Islands. Next slide, please. So the ones that enacted it in 2020 are New York, Virginia, Florida, Mississippi. Next slide, please. So the ones that have been introduced in 2020 in the state legislature, the UPHPA has for evaluation, I guess, is New Jersey, Nebraska, Oklahoma, Massachusetts, West Virginia, Indiana, and Washington, D.C. And it's important to note that, you know, it's not just southern states that are passing the UPHPA. Heirs property, as Robert stated, can affect anyone. And I believe that the Federal Reserve Bank of Atlanta did a study in 2016 that stated about 50% of Americans are facing an heirs property issue because they aren't estate planning. And it's 75% of people of color who are also in danger of passing their land through heirs property. So next slide, please. So as we can see, this is a map of enacted, and introduced. And again, it is a wide range of states, and hopefully it will be one that this map will be all filled out at one point. Next slide, please. So there are two main sections that are relevant to heirs property owners and those who work with heirs property. And that is Section 5104, the relending program, which authorizes the Secretary of Agriculture, this resides in FSA truly, to essentially qualify intermediaries to relent to individuals and entities seeking to resolve heirs property issues and obtain clear title to farmland. So this would authorize groups like cooperatives, credit unions, and nonprofits to for any type of relending project that assists heirs to resolve ownership and succession issues. It provides authorization for an appropriation of up to $10 million annually from 2019 to 2023, I believe. Preference is given to entities with no less than 10 years of experience working with socially disadvantaged farmers, ranchers, and who can operate the program in the states, with the Uniform Partition of Heirs Act as well in effect. So they kind of co-work. So loan terms and conditions, loan interest rate at which intermediaries may borrow funds will be determined by the Secretary or FSA. Rates must be fully disclosed to ultimate borrowers, and the cost of succession planning and other associated legal and closing costs can be included in the loan. The relending program is still, the regulations from what I know are still being approved by OMB. So currently it is in the process of being authorized. But this is technically what this provision authorizes and will hope to do once it's been set up. So next slide, please. So this is section 12615, which allows heirs property to obtain a farm number. So this is just the standards which are needed for an heirs property to enter and get an FSA number, which is huge because this would allow heirs property owners to enter into a multitude of USDA programs where clear title is not necessarily a requirement for eligibility. So before they were barred from even getting an FSA number and therefore were not allowed these programs, which a lot of them provide technical assistance and financial assistance. My program, where I work in conservation easements, it would still not be, we would still need clear market title for an heirs property to enter into any type of conservation easement because of DOJ title standards. But for other programs such as EQIP, a heirs property owner with a farm number could essentially enter into that if they meet the other eligibility requirements. So essentially, just what you would need is the state has adopted the Uniform Partition of Heirs Act, a court order verifying the land is heirs property, a certification that reported owner is deceased, and not less than one heir has started a procedure to retitle the land. Next slide, please. And a fully executed or unrecorded tenancy and common agreement that sets out the ownership rights and responsibilities among the owners of that land. So it has been approved by a majority of the ownership interests in the property, has given a particular owner that right to manage and control a portion or all of that land for purposes of operating a farm or ranch, and was validly entered into under the authority of the jurisdiction in which the land is located. So I turn it over to Robert.
And just one thing that's really important, but that the Farm Bill did do was that, one, if you had majority interest or a group of heirs collectively had majority interest, you are now eligible to apply for the farm number. So that was critical. And then the other one was that there hasn't been any no regulations have been adopted by FSA yet. So getting assistance for clearing title is still not available. It's a promise, but something that hasn't occurred yet. So finally, coming up, you can't overstate this, that if you do not decide how to divide your estate now, the state in which your death is probated, they will decide. And it's not something like people consider, but unless you want Alabama to decide, where your money is going to go or where your land's going to go, then you need to make that decision. Because the first thing the state does when they get land this way is they sell it, because they don't want inventory land. They want the money that the land has. Next slide.
Hello, Robert. I think it's important to state that every state is different. We are doing a Southwide educational program today. So find someone within your state, especially legal, that can help you understand the laws within each one of the states.
And I will also reiterate that what Sam said. There are certain states that have addressed this, and I believe Texas has a statute that would allow you to present some sort of like deceased, document of passing and clear it up. So look into your state mechanisms for any other mechanism to avail yourself from having heirs property if you see yourself in that situation. But definitely talk to any type of legal resource in your state.
And we do have about, just say 10 to 15 minutes of Q&A if you wanted to take those, Lori and Robert.
Well, we got a couple. We have our example coming up real quick.
Yes.
Okay, we'll do that and then move forward.
So at the end of the day, you want to look at two factors that are impacted by heirs property. That is your relationship to the original owner. That is, the closer you are to that owner, basically the greater your share. And then how many generations have passed since the original owner has died. So what we find is over time that you might have more owners of land, but they have smaller and smaller pieces of land. That is, the land becomes what they call fractionated. So to give two examples of this, next slide. That 40 acres and the mule has often been used as a basis for where the newly emancipated were to build a post-slavery future. Over the 155-year period since the end of the Civil War in 1865 to now, there have been 7 3/4 20-year generations. We'll just call it 8 generations. If each member of that generation has 4 children or had 4 children, by the year 2020, there would be 65,536 potential heirs. 65,000. If the number of heirs is divided into that 40 acres, then this would be a shared interest equivalent to 0.0006 acres, basically 26 square feet. This is like 5 feet 1 inch that you could carry. You could carry that in your pocket because of heir property. Next slide, please. Another example would be 1910 has been cited as the height of Black land ownership with almost 16 million acres. That's in full ownership. If that land was divided among the 195,809 landowning African-American farmers in the United States at that time, the average farm size would be 81.5 acres. From that time to this, we're just going to say it's 6 generations. Again, if each generation had 4 children, this adds up to 4,096 potential heirs. If that 81.5 acres is then divided, that is, each heir has an interest in 0.02 acres. 0.02 acres. Next slide, please. So we have a quick exercise for you to think about based on what those 2 examples and what we've been saying in this part of the program. Next slide, please. I want you to count the number of brothers and sisters that you have, and then either on your mother's side or father's side, count the number of her brothers or his brothers and sisters. That would be your uncles and aunts, and then the number of their children, your cousins. Add the number of you plus your brothers and sisters plus your cousins. That will give you the number of potential heirs. Divide that number of potential heirs into that imaginary 40 acres from 1865 or 81.5 acres from 1910. And then what would your share or potential share in acres be? Now, of course, this is more complicated because, you may have no children, and then your brothers or sisters or cousins may have children, and so the line keeps going. But remember, heirs only go until the person up right below the deceased. You may be alive, your children are not heirs, they're potential heirs. You are the heir. So given the number you've divided this into, is it better to keep this land individually or collectively in the family? And then, do you have a similar family situation? I got a feeling some of you do. That is, there's some family land, heir property, and you have a lot of heirs out there, and you need to be thinking about what do you want it? Do you want to have a partition in kind, partition sale, a sale, or do you want to own it collectively as heir property or as an LLC estate and so on? Think about that, please. And thank you very much. Next slide.
So, are there any questions? I see a couple in the chat box. Can you tell me my local contact for the heirs relending program in Macon County, Tennessee?
Well, if you're talking about the program that will help heirs to clear title, again, as of right now, there are no regulations. So there's no entity per se. But hopefully this will be, regulations will be finalized in the near future.
And as to is that different than taking a lien out on a piece of land? It is to an extent, though it might seem similar in when we're talking about the taxes that are being bought, because it might be similar in that regard. Heirs property is an issue with land tenure at the very onset. It's not just a lien. It is you don't have marketable title at that point from the beginning of that transfer. And that's really where the difference is primarily. A lien is just you owe a credit, or you're a debtor and you owe a debt to someone else. And once that's resolved, you know, that has worked out. So like a court can enter a judgment against you, or you can have a mechanics lien for something that you haven't paid. This is essentially a land tenure issue. It's already fractionated. No one owes anybody any money. It's just that we all have an interest in an undivided whole, kind of like shares in a corporation. And that needs to be what is resolved. And we also are at the whims of one heir, because everyone has exclusionary right. So if, you know, Sam wants to timber harvest and I decide not to, I can end that. Or in the majority of people want to timber harvest, I can say no, or I can say no to any improvements, or I can force a partition sale or action. And that's what's very problematic.
So here are two good questions. I'll start with the first one, and I think we all should share our knowledge on this one in particular. Do you have suggestions on how to best do producer outreach on heirs property? Is it challenging, subject to extension educators who do not have the legal background?
There are actually several organizations, a lot of organizations that help with this issue. The Southern Rural Development Center has an heirs property working group that has a listing with some of these organizations, such as the Federation of Southern Cooperatives, Rural Coalition, Land Loss Prevention Project in North Carolina. And they have lawyers that can help with this issue. The Appleseed organization in the South also does some heir property work. One of the major things, especially as extension professionals, is to find out what is the extent of heir property. That is, when you work with a farmer or a rancher, you need to ask them, do you have a will? And if they don't, then you know that there's probably some heir property involved. And then the first thing that even people that professionally work with heir property co-tenants is that the first thing they're going to ask you to do is come up with a family tree. And that will help you decide, or help you realize how complicated things can get very quickly, and what you need to do in terms of homework to help resolve some of these issues.
There are also some working groups called the Sustainable Forestry African American Land Retention Program that was started by the U.S. Endowment for Forestries in Communities, and they're now located under the American Forestry Foundation. And there's groups like the Center for Areas Property Preservation in South Carolina, Roanoke Electric in North Carolina. They provide a lot, and like the Federation of Southern Cooperatives, who was down in Alabama with the LR Lean, which is a Landowner Resource Network group down in Alabama. Those were 4 pilot sites that started with the intent of helping heirs property owners and land tenure issues learn about land resolution, but most importantly, how do you manage your land with using forestry as the carrot. And so those organizations still exist in the 3 states, but they've launched new programs in 4 additional states, which is Virginia, Mississippi, Georgia, and Arkansas. And I think they ended up doing another one in Texas recently started. So I would look for the Sustainable Forest African American Retention. They can help you understand how to get out and do the actual outreach piece of the business. But most importantly, few of the sites do the education around heirs property, and it can help you understand how you can do outreach in your communities.
Yeah, and I just want to say as well that I mentioned that heir property can be the preferred mode of ownership for families. And when you look back, especially in the South, how land was taken away from people, especially on the death of the original owner, and their land, they developed a distrust for lawyers, judges, who found ways of getting their property taken away. That this may have been a way to preserve the land, but today it's not necessarily so. Again, all it takes is one co-tenant who lives, far away, who doesn't even know that they're a co-tenant themselves, to then sell their interests to somebody who then can force a sale. We have a coworker who has some family land in Alabama. They have family reunions there every year. Everything, you get no problem with it being heir property. But then, this long lost cousin showed up, and they welcomed, them into, part of the reunion and everything. And then they said, "Huh, so I have a share in this, huh?" And all of a sudden, some signals started going off of, well, what do you mean by that? And, this is family land. Well, don't I have some rights? And of course, they do have rights. So it only works as long as it works. And all it takes is that one person to decide that they want to do something a little bit different. So something definitely to consider.
Yeah, and to Robert's point, it is a way of doing communal owned land. Unfortunately, our system doesn't, our property law system doesn't really recognize communal owned land, and that's where it abuts, right? That exclusionary right is deadly, for lack of a better term.
We have another question. What is the advantage under the UPHPA and the alternative documentation to get a farm number of having a majority of owners agree versus full agreement? How is this helping families now?
Well, when you get the farm number, then that makes you eligible for those permanent improvement programs that USDA has, whether it's EQIP or other kinds of FSA programs that you can then develop your land. Developing your land then means that you can increase production efficiency, improve your fences, build a farm, build a house,
right,
which then improves the assessed value of the land. It may increase your taxes, but then your community improves as well. So yeah, that's a very, very important way of helping to develop land that before was not open to you.
And
very important from the standpoint that if you just have happened to cut your timber and you're trying to get reforestation dollars, the Environmental Quality Incentive Program, EQIP, will allow you to apply for the full funds to help you do the reforestations on your land, which is actually get the site prep and the planting of buying the trees and planting the trees back. So the farm number is a critical number, just like your ID number, for helping you get access to those programs in NRCS and some of FSA.
Right. And the advantage of the UPHPA is that a lot of the Farm Bill language comes from the UPHPA. So it would just be easier to get a farm number if you're already in a state that has the UPHPA. And because it's easier to certify that you have heirs property. Like there's a, and I'm, again, this is, please talk to a lawyer that practices this, but it is just, you can certify that you have heirs property at a court of clerk in that particular state. So it's just more advantageous. And I see versus full agreement. So if you have a full tenancy in common agreement on how that land is divided and how it will be planned out by that family, then you don't necessarily have heirs property issue at that point. Hopefully you've taken into succession planning as well in that agreement, because that agreement then defines the clear roles and what people have owned, and that mediated agreement can be entered into the court and seen as that. When the Farm Bill says if there is a tenancy in a common agreement, I think that wrong stated also that it hasn't been executed, and that's just another evidence saying I have heirs property and I still have heirs property, and here is, we tried to resolve it, it's not resolved yet. So I hope that kind of also answers that question.
And also with the UPHPA, I was talking on a conference call with one of the authors, Thomas Mitchell, and it had been thought, I had even thought, that if you are part of an heir, part of a partition action, you had to then tell the court about the UPHPA. That is not correct. That is, the court should know to invoke the UPHPA if that state has adopted it. If they take some other legal, let's say the previous legal remedy for partition action, and they don't invoke the UPHPA, and it's in that state, then that's a cause for direct appeal because they used the wrong law.
They robbed you.
Right. One of the key things with the UPHPA is that it gives you time. I've had a lot of calls that say, the land is coming up for auction. What can I do? And I said, well, when is the auction? They say, this weekend. I said, there's not a whole lot you can do. But with the UPHPA, it gives you that time so that you can get the families together. You can do the right of first refusal, and you can have, the independent assessment and so on. So it's a very, very, it's not the end all and be all, but it's certainly a good start.
Right. It essentially takes you from being seen as a credit debt sale, which you shouldn't be, right? It gives you substantive due process rights, and that's very key.
We are a nonprofit, and we have a legal department and a forestry department that can provide contact information if needed. Please do, and tell us what state you're in. Are there any other questions?
Great. And really now we're just at the point where we'd like to just open the floor for any other comments or questions that you all have. I want to thank all of our presenters today on the definitions of socially disadvantaged farmers and ranchers, some of the provisions in the Farm Bill, our statistics about the history of representation of socially disadvantaged farmers and ranchers, and this deep dive into the issues of heirs property. Today is a lot of the sort of technical side and sort of the legal sides of issues that are most challenging to this population. And tomorrow's discussion is going to be much more about planning and strategy. So we'll be talking about how to identify partnerships to access markets, innovations in markets, and market opportunities for this population. We'll also be having a very critically timed training in identifying farm stress, so mental health stress in farmer and rancher populations, and some training about farm stress, mental health, first aid. And I'm very excited to have that discussion. And finally, we'll be wrapping up tomorrow with a discussion on equity, justice, and access, which really won't be a wrap up at all so much as more of a kind of maybe diving in and figuring out maybe some new courses of action that are being taken and need to be taken in the future as those are all really incredibly poignant and relevant issues right now facing our country. So that's a little bit about what we've done and where we're going. I'd like to just leave, we have some free time right now for anyone else to ask questions of any presenter today, or if you'd like to ask questions about what is coming tomorrow, this is the time. You may do it in the chat, or you can unmute yourself and ask through your microphone.
Sarah, we gave that example about the air property, and I was wondering, Sam, was about, does anyone have any comments about that on a personal level?
Hello there.
Hey, Lorette.
Hello?
How are you doing? This is Lorette Pachano, and thanks so much for all of this. And I think my colleagues can help answer this question, but basically getting a court order, and like I'm right now working on 2 estates, and just getting paperwork and all of that, even if there is a will, is a really hard thing to do. So number one, if you don't have a will, please get in touch with the groups listed and get a will, and make a succession plan for farming. But going to court and getting a court order under the Uniform Partition Act really is kind of a stop action that stops negative efforts. And you know what we know is there's venture capital funds that are right now the teachers' pensions. TIAA-CREF is buying farmland all over the country. And so it's really important to protect land. And then the other thing I'll say is there's a third farm bill, a third section that all of us working together help win in the farm bill about getting a NASS study, National Ag Statistics Service, of land ownership, how much farmland is held in absentee ownership and undivided interests. And there was 3 million authorized, but it's not yet been funded. So anybody who wants to get in touch, I'll put my email in a chat box because we're continuing working on that effort as well. And thank you very much, Robert and colleagues, for all your work.
And just to follow up quickly on what Lorette was saying, we've done studies on air property, and just as air property is assessed at a lower rate than property with secure title, air property that has absentee ownership is assessed at even the lowest rate. So again, this is a community issue where they are losing, as well as the landowner who owns some land but is not able to take care of it because they live either in a different county or a different state. So again, absentee ownership is a big issue as well.
I want to also thank Lorette for your comment, and it jogged my memory that we recognize that so many of you are also experts in your own right and are sort of innovating in these areas, and we would encourage, not in this time, not just if you have a question, but also if you have a resource to share, just as Lorette did, mentioning what she's working on and then dropping your email. This is a time we really would like to give the floor to you all for you to speak up. So thanks, Lorette, for paving the way on sharing resources as well.
I have a coworker whose tax bill was for inherited property were sent to farmland where no one is living, and thus went into delinquency. She nearly lost her family land. That is very common in a lot of states, and it's very important that people keep track of who is paying the land, and so in case someone stops paying the land, that you can pick up the taxes, because people will let your land be delinquent.
Yeah, it's very important because usually you have somebody that may be living on the land and they've been paying taxes, for 30, 40, 50 years. And, either they move or they pass, and then, you have to keep track of that because you forget that those taxes are coming due. And then it goes up, they become delinquent, and they have your tax sales. And in Macon County, the revenue commissioner says every April, they have 3 major buyers from the surrounding counties that come in and they look at the choicest pieces of land. And they have they have the cash on hand, and they buy these tax deeds. And the key thing is they get 12% interest. There's nothing else that you're going to get right now that's legal that's going to give you 12% interest. So, anyway, be cognizant of that.
There was also, just wanted to uplift another comment in the chat here, and this is actually back to Lorette. Someone wanted to know about your NAS study, and it looks like she's responding to it right now about whether or not the study will examine the impact on minority land ownership. I'll just let the group kind of follow the chat there, and for those who are joining us by phone, I'm going to just read it out loud. Lorette responded and said that we've been pushing NAS on including demographic information on race, gender, and ethnicity in the land ownership total for land surveys, and doing the surveys well is very important and costly. We need to get this study first funded and then take this up in the new farm bills. Thank you for sharing that. And I'm also going to, as the last kind of questions are coming in, I'm also going to extend the invite to my SRDC colleagues to please post in the chat the links for tomorrow's Zoom as well. We want to make sure that everyone has easy access. If you do want to join us tomorrow, we'll just drop that link in the chat so you can just copy paste it, save it on your browser so you can join us bright and early. Thank you, Catherine Spiring, for doing that, for dropping the link in for tomorrow's session. And I think I'm also going to just turn it over to Sam, who's going to eventually kind of close us out. So Sam, back to you.
Great. I hope this was a very informative day for you today, this morning. And we thank you for taking the time to participate. I know we got a lot out of it, and we enjoyed putting our time and effort into presenting to you. Looking forward to tomorrow. We'll kick off tomorrow again at 9 a.m. We talked about the agenda earlier, and be a little different format, but we hope that each of you sign up for day 2 because it's new learning, new information, and very engaging. So once again, thank you.